Okay, we all want to go last.
Okay.
That's good. That's good. I bought a glass of wine last night, so I got the glass. I bought a glass of wine too. That was my mistake. It's overpriced. It works. It's the downside of not making the deal.
Good to go? Good morning, everyone. My name is Kwon. I work at the Colorado Attorney General's office, and I have the pleasure today of introducing what I refer to as the water gurus of Wyoming, Nebraska, Kansas, and Colorado. They're otherwise known as our state engineers, who lead the administration and enforcement of water law in their respective states. Included in these efforts is their responsibility and authority to administer water, to realize the benefits and exercise the obligations of numerous interstate compacts that form the backbone for allocating water throughout the West. Focus in recent years, I think, as Justice Hobbs had just pointed out, as you've seen in the press a lot, focus in recent years has frequently been on the Colorado River as one of the most regulated and litigated rivers that serves to supply tens of millions of people, thousands of irrigated acreage, thousands of native and endangered species, critical industries, and hydropower, not to mention important tribal cultures and binational needs. A number of other compacts exist that allocate significant rivers throughout the region, including the Platte River Compact, Republican River Compact, Arkansas River, and Rio Grande, to name just a few. We brought the state engineers from these states here today who have grappled with each of these compacts to explain how they work to implement the terms of the compacts, protect their state's interests, and achieve the benefits they bargained for in those compacts. So we're happy to have them here today, and we're going to introduce them one by one here. First, we're going to start with Kansas State Engineer David Barfield. David graduated from the University of Kansas with a Bachelor of Science in Civil Engineering in 1978. Following graduation, he worked for 3 years in consulting in Minnesota and 3 additional years in a developing nation in, southern Africa, very similar to Colorado. In 1984, David returned to Kansas and joined the Kansas Department of Agriculture's Division of Water Resources. He's earned a Master of Science in Water Resources Engineering in 1991, and that was also from the University of Kansas. At the Division of Water Resources, from 1984 to 1987, David performed special studies to guide water management decisions, and from 1987 to 1992 served as the head dam safety of the Dam Safety Unit. And from 1992 to 2007, he led the technical efforts related to Kansas's interstate water issues and became very familiar with Colorado's technical entities as well. He primarily worked on disputes regarding the Republican, the Arkansas, and Missouri rivers. David was appointed acting chief engineer in June 2007 and has served as chief engineer since December. He's only the 5th chief engineer in the division's 85-year history. In this capacity, David directs the staff of the Division of Water Resources in fulfilling their broad responsibilities over the state's water resources, including administration of 4 interstate compacts, more than 30,000 active water rates, and the safety of thousands of dams and water structures. We welcome David Barfield.
All right, thank you, Karen, and it's a pleasure to be here. Appreciate the invitation to serve on this panel. I think it's going to be a fun one. So I'm sort of here to represent one of your downstream neighbors, as Justice Hobbs said. These are shared resources, and it's quite an adventure figuring out how to share them. So, as a state engineer, my predecessor was sort of the one at the table, sort of one of the principal people at the table, trying to negotiate these things and figure out how they should work. And now as a state engineer, I'm either the sole, for Kansas anyway, I'm either the sole or sort of lead commissioner on the compact administration, sort of making sure we do our job and making sure we get our entitlements on the compact. I think it's, as the state engineer on the commission, it's sort of part of my job to identify when we have a dispute and to sort of walk us through the dispute mechanisms of the administration and beyond, often in partnership with the Attorney General's office. Unfortunately, you know, change happens. You know, if these compacts, I think David Robbins last night spoke, and you know, they were all done at a point in time, and I think all generally fairly well done. If change didn't happen or unanticipated change didn't happen, they'd probably work just fine. Unfortunately, the reality is compacts that were negotiated in the 40s, in the case of the two that are in dispute with respect to Kansas, you know, lots changed in those years, and as things change, sometimes we have to adjust these compacts, but adjusting these compacts are very difficult. And so we're going to sort of walk through. I'm going to sort of focus on the Republican River. I've got a map here. Kansas has 4 interstate compacts. The Republican River that was negotiated in 1942, ratified in 43. The Arkansas River, as we call it, that was negotiated and ratified 48, 49. And then we have 2 later compacts that really have had little dispute, partly because I think as later compacts, we had more wisdom about some of the things that are affecting these earlier compacts now. And again, the principle, at least in the 2 compacts that we're going to be focusing on, that Kansas is involved with, the principal change that happened is groundwater development, substantial groundwater development that's connected to the surface water system and affects it. And it's taking time to work through that because it's a technical challenge. Not every acre-foot pumped from a well affects the stream an acre-foot. There's a substantial lag in effects and other things that affect the amount of depletion from that well to the stream. And so factually we sort of have to figure out how does this work? And then again, groundwater is not mentioned in either of these 2 compacts, and so how do we fit it in the compact framework? So again, we've been working at this for decades, and and really we're making progress, I think, on both of them. But again, I'm going to focus on the Republican River. I think Dick's going to make some comments on the Arkansas. So the Republican River Compact, again, this is one maybe a lot of you don't know much about. It came about, the Republican River Basin was largely undeveloped in the 30s, and so we had a very major drought in the 30s, and it was punctuated by a very significant flood in 1935 that sort of started in the South Fork, really in Colorado, and then ravaged the valley. At the same time, there was a lot of federal discussions about by the Bureau of Reclamation and the Corps of Engineers about systems of reservoirs and irrigation districts that could retime the floodwaters or excess waters and really be a part of the development. So the basin really wanted the system of development to occur, and this is actually a map of what actually occurred after the compact. But the federal government said, before we're going to invest in this infrastructure, the states need to negotiate a compact, and then the development of these reservoirs, irrigation districts, would be pursuant to those allocations, and everything would work well. Great idea. And so what they did is they basically took the records of the 30s and early 40s, a little bit longer, whatever records they had for each of the tributaries and the main stem of the Republican, and they also had plans in terms of these plans by the Bureau of Reclamation and the Department of Ag Economics that said this is where we think the development's going to occur. And so they determined the water, the size of these little pies, or sort of how much water is in each of the tributaries, and they allocated portions of it for use by the states and the tributaries, and the white portions in the tributaries were reserved for the main stem, where they expected most of the development to occur pursuant to those reservoirs and irrigation districts. So basically the Republican is sort of an allocation framework. It's really a fairly straightforward compact. It has provisions. They knew the records of the 30s was not the end of the story, so the allocations sort of float up and down. And basically the theory is each state keeps their use and their share, and then the downstream states get their share. So the unattested, so what happened? So this is a depiction of the irrigated acreage developed within the Republican Basin from groundwater only over time. And as you see, the state of Kansas is the blue line at the bottom. We developed in northwest Kansas about 250,000 acres of irrigation within the basin. You know, in the late 70s, we began to see we're developing beyond the long-term sustainability, and so we sort of shut down our irrigation development The green is Colorado. They sort of developed about 500,000 acres in the plains of eastern Colorado Republican Basin. Again, we say they basically stopped development. And then the red is Nebraska, and they just kept on developing. So we have a problem. And eventually, again, it takes years and sometimes decades for these effects to manifest themselves in the stream flow. So it took some time for this to happen, but eventually in the late 80s, we really started asking questions. In the late 70s and the mid 80s, we began to ask some very pointed questions about how is this supposed to work. And the early 90s, is sort of when I started as a team to sort of focus on getting this fixed, and brought some resolutions to the Compact Administration, and in 1995 we sort of put something on the table, and Colorado supported us, Nebraska said no, and we were off to a litigation path. We sort of took a brief attempt through mediated settlements to try and come to a solution, but really the state engineer at that time and the Attorney General said, Kansas doesn't have a case. This is a surface water compact, and sort of defeated that attempt to resolve it. So in 1998, we went to the U.S. Supreme Court and said, Nebraska's violating. We need to fix this. Nebraska asserted its theory. This is a surface water compact, and so the Supreme Court appointed a special master. And the first issue that was the briefing was done on is groundwater included? Nebraska argued no. Colorado said alluvial pumping effects should be accounted for. The compact had methods that quantified the alluvial depletions, and so that was Colorado's theory. Kansas said to the extent that groundwater pumping is affecting the surface system, it should count. Special master agreed with Kansas, and the court affirmed that. So after that decision, basically Nebraska asked the states to let's try and settle this. And special master was taking a very let me back up here. These apportionments by basin, the development didn't happen exactly like that, and the special master was taking a very sort of literal approach, and was sort of motivating the states to settle this because we didn't develop exactly according to this pattern. So actually, the states did go to the table, basically negotiate a settlement, so that the trial was settled by this settlement. It basically developed clear agreement on how we were going to do this, the test of compliance. We had experts, modelers, and data people that were sort of building our competing models to fight the battle in the court. We put them all in a room and said, we want one model that says how these groundwater depletions, groundwater pumping are depleting the surface flow that we're going to use in our accounting. We provided some flexibility between subbasins and multi-year test of compliance that was a part of that. Again, the groundwater model was a very important piece of this agreement. This is a depiction of sort of the irrigated acreage within the states. So 2003, we have a settlement. Everybody's happy. Everybody's saying we succeeded. Colorado and Nebraska knew they had some issues. They went off to sort of create their compliance mechanisms. Unfortunately, within a couple years, the basin was in drought again, and again those allocations go up and down. So they come down during dry periods. Much of the use of the water is actually in groundwater, and you can't turn those off. And so that's when the compliance problems happen. And so Nebraska essentially failed the first test of compliance because they didn't respond quickly enough, and partly because we started with a drought. We went back to the Supreme Court, basically sort of tired of this, because this really was sort of the third violations and shortages to Kansas that resulted from those violations. So we asked the court to stop this, and that we wanted damages pursuant to Nebraska's gains, which were almost an order of magnitude larger than our losses. And we wanted the court to specify a remedy that would prevent us from having problems. I didn't find a map, but this is a graph that sort of shows the rise in groundwater depletions to stream flow from Nebraska's groundwater pumping in red, and then where the line forks is sort of our projections about where those are going in the future, pursuant to the level of pumping they had at the time, and the blue is if if the court imposed the remedy that Kansas sought of essentially going from, they had about 1.2 million acres in irrigation. We said the 300,000 that's close to the stream ought to just be shut off. And so then the depletions would fall to that blue line and we'd get our water. So the ultimate decision by the court was to find Nebraska in violation, to provide that the appropriate economic remedy was Kansas losses and a small amount of their gains this time. But the special master recommended to the court that next time the hammer should come down. This is the first time that the court, I believe, has ever sort of used this theory. So it was a highly contested matter here. But the court said Nebraska ought to be able to determine how to get in compliance, and so those are sort of the results of the litigation. Meanwhile, the states are working very hard, even as all this is going on, to get their mechanisms in place. Again, Nebraska had recognized it hadn't done enough, so both Colorado and Nebraska have done quite a bit. They've been retiring groundwater through some federal programs, surface water buyouts. Colorado drained Bonnie Reservoir as they were charged for the evaporation from Bonnie Reservoir, a very difficult action. And then principally, though, those actions are not enough, and so they've been developing these augmentation projects. We've had disputes about those augmentation projects. They're required to have compact administration approval, and so this is just a depiction, and I know there's not a lot of detail here, but Colorado has developed its augmentation project on the North Fork Republican River. That slick handout, I took a quick peek, and it's very nicely done. It shows the South Fork goes through Kansas. What's labeled as on the North Fork on your map is actually the South Fork, and the North Fork is right up here. So they put their augmentation pipeline on the North Fork because it's just has a better water supply and a shorter path to the river and that sort of thing. The problem is they overuse both the North Fork and the South Fork. And so we've been reluctant to agree to the North Fork augmentation pipeline that flows into Nebraska until we come up with a fix to their South Fork overuse. And then Nebraska has two augmentation projects, one on Rock Creek and one on sort of the divide between the Republican and the Platte that they can use for either basin as they need to. And, the challenge of these are a long way from Kansas, and how do we deal with losses that occur between where they are, and how do we ensure that Kansas can get its best use of that water, because they're doing this because they're overusing their allocation, and that water is due to Kansas. So just to end up here, so we had these arbitrations, and they sort of ended the summer of 2014. The next step can be, now we're free, pursuant to the final settlement, to go to the Supreme Court, but all of us are working hard to find a way to not do that. We've been having monthly discussions to figure out how to integrate, especially these augmentation schemes, into the compact, so they can comply and we can get the best use of the water. So we've I think it's 5, maybe 6 short-term agreements have been negotiated between the states to sort of try out the accounting and some of the mechanisms to make sure we can make good use of it. And we're working hard toward long-term agreements. So I'll stop there. And Karen, probably we want to do questions at the end? Or?
Yeah.
Okay, very good.
So you have a flavor of how Kansas views the Republican River. I'm sure if we had Dick Wolfe or Jeff up here talking about the Republican, they could provide a little bit of a different view from the same perspective. But next we're going to have Jeff Fassett from Nebraska. He was appointed the director. He's not a state engineer. He's the director of Nebraska's Department of Natural Resources, and he was appointed in July of 2015. As director, Jeff oversees all activities of DNR as more than 100 employees work to provide the sound science and support for managing Nebraska's most precious natural resource, water. Prior to directing DNR, Jeff was most recently the director of the Water Rights Strategic Program for HDR Engineering, where he was involved with water supply, water rights, and water resource development projects across several regions and states. During this time, he also kept a water rights and water resources engineering practice in Wyoming and Colorado for a wide variety of municipal, state government, energy, mining, and private landowner clients. Previously, Jeff operated Cheyenne-based Fassett Consulting, an engineering consulting firm that specialized in water rights, water resources engineering, and water policy matters. Additionally, Jeff served as the state engineer and chief water resource official in the cabinet of the governor of Wyoming for 2 administrations. He holds a BS in civil engineering from the University of Wyoming, and he's a registered professional engineer in Wyoming and Colorado. Under Director Fassett's leadership, DNR's mission in Nebraska is fulfilled through 5 key focus areas: water planning and interstate water management, support for floodplain management, monitoring the safety of dams, permitting the extraction and use of stream flows, and the collection of natural resources data. Please welcome Jeff Fassett.
Thank you, Karen. Like my fellow colleagues up here, I'm very pleased to be here. Actually didn't take long to get us here. We're all good friends. We see each other all the time. But we have to keep an eye on each other. So, you know, once one is going to publicly speak, we better all come and listen. So, I was completely changing my talk as David was speaking. So, the summary is they're just hard to please. Anyway, as the introduction suggested, I've got sort of a different perspective. It's fascinating if you listen carefully to what I've done to myself. First of all, I'll just touch briefly the fact that I have now been a state engineer in 2 different states. So I've gone from the headwaters view to the downstream or the sandwich state view. And then secondly, I wanted to comment, it wasn't part of the introduction, but I'm also finishing up a 12-year stint as a federal commissioner on an interstate compact commission. During the time I was in private practice, I was appointed by 2 different presidents to be the federal representative to a compact. So I wanted to throw that into my remarks as well, just a different role, having been a states guy. To all of a sudden have to be a Fed is a difficult shift sometimes. So I was in Wyoming. I was Pat's predecessor. He's going to get to talk about some stuff, but I get to talk about the pain and suffering I went through on the North Platte, which again was triggered by the state I now represent, who sued the state of Wyoming back in 1986 over the equitable apportionment interstate decree that was established by the United States Supreme Court in 1945. The 45 decree took 10 years of litigation, started in the 30s. So basically Nebraska and Wyoming haven't gotten along on the Platte for a really long time. So we had a 45 decree. 40 years later in the mid-80s, Nebraska was alleging some violations of that decree, so we charged off to the Supreme Court to resolve that issue. That case started about 6 months before I became the Wyoming state engineer. Basically lasted my entire career until I left in 2000. The highlight, though, is after about 20 years of litigation, about $20 million apiece, Nebraska and Wyoming did achieve a settlement, and did achieve a settlement literally on the courthouse steps the night before opening arguments in front of the special master after 15 years of preparation work, depositions, field trips, more technical resources being committed from both states. We did finally come to closure. The lawyers that were involved at that time didn't talk to either of us as the state engineers in both Nebraska and Wyoming at the time for about 4 or 5 months. We had pulled out what they had worked so hard to prepare for at the very last moment. The experience of that litigation, though, was that while it got started, cases of this nature literally take on a life of their own. They're not that hard to start, but they are very difficult to stop. And it is, I think, because you are in the environment of the United States Supreme Court, you get one shot and one shot only to sort of get it right. My personal assessment is it took a long time, but eventually both states, I think, ultimately became a little nervous about what the special master's views in drawing his rewrite of the interstate apportionment decree might look like. And that together was perhaps a very good motivating factor to both states who clearly thought they were both going to absolutely clobber the other one. We were beginning to get signals that it might not quite fall out that way. And so during the 15 years before we got to the final settlement, there was at least 5 attempts at trying to head off the Nebraska v. Wyoming case. And I want to just share shortly about that because at the end of the day, it took personal relationships between the major parties. It took a change in the players amongst the states, the 2 states and the federal, in this case, the Bureau of Reclamation, who was a major player on the North Platte, unlike other basins. But it ultimately came down to the water officials. It came down to the local water administration officials, the state engineer's office, to really develop the final settlement. We had 4 or 5 attempts of different mixes of representatives from the states. The early versions all included some of the legal teams on both sides as part of the settlement group. And it was pretty clear that was not going to be conducive to finding a resolution. People were, after years of preparing for their case, the lawyers were just being good advocates for their states. And they were just not in a position to really concede and to find the compromise on their own. And it took the water administration folks in both states working with ultimately the water users in both states to actually frame the settlement that we achieved. We achieved the settlement in the year 2000, and that's when I left. Pat inherited the deal, and he can comment about how we did. But that was a crowning moment and a wore me out moment for me as the state engineer. That was overtopping. That activity was a significant reserve water rights case up in the Bighorn Basin that was also throughout my career as the state engineer in Wyoming. So after that, I went to private practice. Initially, I needed no boss, no staff. That was a great move, but sure enough, 15 years later, the lure of being in the kinds of positions that we all get to have was too strong. And so I was approached and took up the opportunity that Governor Ricketts offered me to go back into the public sector to take on the Chief Water Resources position for the state of Nebraska. A fascinating intellectual challenge at this point in my career. And so I'm now on the other side of implementing the settlement that we achieved with Wyoming. Pat and I just came from a meeting this week, so it's a pretty interesting dialogue and discussion amongst the parties at that point. But the lasting effect of that particular settlement, in my view, and Pat can give you his own perspectives, is that you don't hear about a dispute on the North Platte River anymore. That is the lasting effect of the settlement that we achieved. As hard as that was, the enormity of the process that we all went through, at the end of the day, there simply is not a dispute. We ended up generating a very clear, predictable, readable, implementable settlement that people on the ground can understand, not just the officials and their legal counsel. And that really, in my view, was a great signal of the ability to put something, hopefully, to rest. But who knows? My perspective is changing already, so maybe we'll sue again. I'm learning how to be a downstream state. So we're implementing, I've switched, I'm now the implementer of the Nebraska side of that case. And of course, I've inherited the situation that Dave Barfield just described to you. As I've told a few people, I didn't ask enough questions during the interview phase. I thought they had a settlement. As it turns out, Dick and David and I get to meet every month of our life, whether we need to or not. And we are very aggressively working on the finer details of really trying to achieve what I think we did on the Platte, a much clearer, concise, implementable, more permanent, lasting understanding that not only the state officials can understand, but that the public at large, the water users at large in the 3 states of the Republican River can ultimately understand. I think that's the only way we're going to achieve less litigious environment going forward. For Nebraska, you saw the charts. I mean, you know, there's a reason 5 of the largest center pivot manufacturing companies are based in the state of Nebraska. In whole, we are the #1 irrigated state. It's about 9 million acres. 8 million of it is from groundwater pumping. Only about 1 million acres in the state of Nebraska is actually irrigated from surface water rights. The Republican is no different. It's about 9-to-1. We got in round numbers 1 million acres in the Republican River Basin within Nebraska. 900,000 or so of that's irrigated from groundwater. It is a very dominant activity, and then I am now the chief water official of the state that has 2 very distinct surface and groundwater systems, which were only brought together about 10 years ago under state law. And so the idea of integrating surface water and groundwater under state law is a huge challenge. It's a very difficult planning process between myself at the state and 23 local natural resource districts that exist all across the state of Nebraska. It's a very different system of how, under state law, as Justice Hobbs was describing, we integrate the surface and groundwater supplies. That's clearly a gigantic challenge for us when we then face the interstate obligations and the direction that the Supreme Court has given it, as Dave summarized. So it is an area of the state where, unlike Wyoming, lots of people in Nebraska have the benefit of a lot of water. The state is blessed like I cannot believe. The bad side of having a lot of water is when you finally don't have enough and you begin to regulate. Most people believe life ends as they know it. And I came from a world that Pat is now in charge of, where the prior appropriation doctrine and the implementation, the regulation of that system is routinely and actively carried out year in and year out. Even in the wettest years, people are being turned off in priority in Wyoming. That is not the experience I have now in the state of Nebraska at all. And so as these new decisions, these new agreements, these new enforcements come at us, either from within or exterior to our state through the compact, it is requiring regulation to people who have never, ever, ever been turned off before. So they brag loudly about the prior appropriation doctrine as long as you don't enforce it. They think it's the greatest thing since sliced bread. They're gonna, this is a states' rights thing. Oh, does that mean I'm turned off when there's not enough water? I didn't know that could ever happen. It's a great challenge for the state of Nebraska. I'm making light of it because it's real. And if you look around the West, some of the biggest fights as we begin everywhere incorporating depletive groundwater effects on our surface water streams, it is enforcing regulation on people that have never been regulated before. And that creates the local problem. It creates enthusiasm for state legislatures to try to craft laws to avoid that result, and it just makes the problem more complex. But it is a great challenge to sort of take that on. As I said, I'm trying to learn how to be a downstream state. I've looked around, Dick, I'm sorry. The only place I got to go next is to sue you on the South Platte, I guess. So, everything else has been litigated, so, you know, I got to try it out. So, I thought it'd be fun to be a plaintiff instead of a defendant before I end my career, just to try that side of the formula. So, let me talk briefly about being a Fed. Because of my change to Nebraska, I'm going to step aside from that role. But while I was in private engineering practice, I was approached by my colleagues, other colleagues just like these gentlemen, who are in Oklahoma, Texas, Louisiana, and Arkansas. And they share the Red River Basin, have a relatively new compact, a 1950s era compact, allocating water, talking about flood control, a compact that talks about water quality, a compact that talks about navigation, of all things. And their traditional federal chair under that compact commission had always come from the Federal Corps of Engineers, because they only wanted to talk about flood control and navigation. And Texas and Oklahoma sort of tired of that. On the dry end of the Red River Basin, they wanted somebody that had a better understanding of prior appropriation, of allocation aspects of interstate compacts. And so after some frustrations with federal chairs for a long time, those states reached out. They found somebody in Wyoming that knew something about compacts but had absolutely no interest in the 4 states whatsoever, and I think that's why I got picked. They elevated my name. I was appointed to be the federal chairman of an Interstate River Commission. It's a 9-person commission, 2 from each of the 4 states and a federal representative. In this commission, and there's a mix of examples all around the country, this particular Interstate Compact Commission, the federal chair does not have a vote. So there's lots of opportunities for upper basin, lower basin, 4-to-4 ties that will not be broken by the federal chair, and that is by design in the compact itself. But it is a unique setting. It was a very fascinating experience for me. You have 2 prior appropriation states, 2 riparian states that are all a party to the same compact. The lower basin states, just when they get ready to kind of get mad at each other over allocating under the riparian system across the state line, they're almost ready to start suing each other under the compact. It rains. And it rains like 25 inches. And all of a sudden everything's underwater and the issue goes away for a couple of years. But Oklahoma and Texas like to fuss with each other on the upper end of the basin. And so it was a great opportunity for me to bring my experience from Wyoming, working with the prior appropriation doctrine, the myriad of compacts that I'm sure Pat will touch on that Wyoming is a party to. He's got as many as Colorado, I think. To be a player, though, and to bring some expertise in a very neutral capacity to the discussion among the states, because you did not have a vote. I couldn't threaten anybody, but I was still the chairman and could guide the discussions amongst those compacts. Later in this conference today, you're going to be hearing about the Tarrant Regional v. Herman case, which was a case in the Red River Basin. Interestingly, those feuding parties did not come to the Interstate River Commission procedurally. They decided to stay in federal court and elevate themselves to the Supreme Court without coming through the commission. Quite honestly, the commission thought that was a flaw procedurally, that the dispute should have maybe first come to the Interstate River Commission, since it was a matter of interstate law and interpretation of the export situations between Tarrant and the state of Oklahoma. But it never did come to the commission. It was on its own track, and you're going to hear a lot about that case later in this conference. So the federal role was sort of interesting. I had to coordinate with a lot of federal agencies who were wondering why a guy from Wyoming was the federal chair. But it was a great experience to sort of bring how regulation really occurs and how it needs to happen to areas that don't see much regulation, and to really have them think about some very basic concepts that Delph Carpenter and others were talking about 140 years ago. You mean like measuring water? Louisiana was complaining about Arkansas's behavior, and they're saying, well, how much water do you need in Louisiana? They go, well, we don't know. It's a little lower today. We want more. Just send us more. That didn't sit well with the upstream states. So they're really beginning to talk to some very basic concepts amongst the riparian states, as well as the prior appropriation gang upstairs. So anyway, that's my view. I'm going to stop as well, and we'll be happy to take some questions later. Thanks again for having us today.
Okay, batting third, we have our state engineer from Colorado, Dick Wolfe. Dick was appointed state engineer and director of the Colorado Division of Water Resources in November of 2007. In this capacity, Dick is responsible for the direction and management of the Colorado Division of Water Resources, as well as manhandling sometimes the attorneys in the Attorney General's office. He has a staff of about 297 employees and an annual budget of approximately $23 million. Division is responsible for distribution and administration of water in accordance with state statutes and interstate compacts, the implementation of a statewide dam safety program, and the permitting of the use of groundwater and construction of wells, and the collection and dissemination of data on water use and stream flow, among many other things. The state engineer in Colorado is the commissioner on 5 interstate compacts and is responsible for assuring compliance with all of these compacts. The state engineer is also the executive director for the Groundwater Commission and the secretary of the Board of Examiners for water well and pump installation contractors. Dick's education experience includes a BS and an MS in agricultural engineering from CSU in 1983 and 1986 respectively. Please welcome Dick Wolfe.
Thank you, Karen. Appreciate that introduction. And Justice Hobbs, it's always an honor to follow you. It's always a tough challenge after your presentation, but I think you did a great job in providing some of the background, the history, the compacts that all of us have to deal with these days and trying to administer those. So and I want to thank Blaine too for the invitation and Denver Water Law Review for allowing us to participate in this proceedings today. I wanted to comment a little bit. Jeff was threatening to sue me, but I'm a little frustrated by that. We sent over 2 million acre feet to them last year, above our compact requirements, and I'm still waiting for all of our gauging stations that went down there during the 2013 flood that you haven't returned yet. So if anybody has a complaint, it's me against you. So
We're never satisfied.
no, never satisfied. You know, we talk about our careers and our history too, and I started thinking about that in the presentation for today and thought about next month will be my 30th year since I graduated from Colorado State University, and I've been in the same career in water resources. Started out my first part of my career as a consulting engineer for 7 years, was a private consulting firm, interestingly enough, representing Kansas in the lawsuit that was filed in 1985 against Colorado. I'll have to say though, during that 7 years that I was employed with that firm and working with David Pope and David Barfield and their staff on this, I never picked up that slang of how to pronounce Arkansas. So anyways, we've come to, this is a great thing about negotiations when you're dealing with compacts. We've come to an agreement during our discussions. It was mentioned we're meeting monthly, and we've just now commonly referred to it as the Ark River. So we don't have a continuing dispute over how to pronounce the Arkansas River. But I wanted to talk about some of what I see from my perspectives. All of the folks here are going to bring some of their perspectives to this as well, and so I wanted to share with you some of my perspectives that involves particularly the Arkansas River Basin litigation there, having spent so much time on that early on in the first parts of that litigation, and then when I joined the state of Colorado and continuing those efforts once that 24 years of litigation ended and the U.S. Supreme Court finally entered their final decree on that. As David Robbins had indicated last night in our dinner, this was really the first time for Colorado that we had employed the use of a computer model as part of that compact litigation. And this was instrumental in terms of trying to understand the technical aspects of the interaction between surface water and groundwater, particularly as it relates to the groundwater pumping. So, as you know, when these compacts were set up, they were an alternative to the litigation method. Justice Hobbs talked about some of these cases that were litigated before the Supreme Court, and a number of our states are still administering final decrees that were entered as part of those litigations between the states. But as Karen mentioned, you know, we have 9 interstate impacts in Colorado and a couple of U.S. Supreme Court decrees. So I've learned with all of these compacts that, as we've heard, that they didn't anticipate these modern developments that we're thinking of. If you think about the compacts in Colorado starting in the 1920s and developed through the 1960s, I know those folks who were involved with them back then. Justice Hobbs talked about Delph Carpenter and all of the technical folks as well that were part of the development of these compacts. And they really were an effort to understand a lot of the technical aspects and what they were dealing with from a physical sense between these basins. And so there's a lot of smart people that were working on these, but I'm sure as we sit here today like they were back then, you could never anticipate some of these things that are coming in the future. We try to anticipate and think about those, but those are certainly the challenges that we face. And I'm sure back then they may have thought of that, but I'd hope maybe the way these compacts were structured and the folks that would follow, they would certainly rise up to the challenge to deal with them. And for example, you know, we did not anticipate the considerable development of groundwater in the 1950s through the 1980s. You know, it took some time for the science and the law to catch up. And so also these compacts did not envision issues with the Environmental Species Acts that came about in the 1970s, reserved rights and bypass flows. These are all some of these contemporary issues we're dealing with that weren't considered when these compacts were originally developed. They didn't consider the effects of climate change. Now we're maybe dealing with some of those effects today. There's anticipated to be greater changes in climate change as it affects the timing and amount of runoff, the evapotranspiration of crops and the native vegetation, as well as higher evaporation from the reservoirs that exist within these watersheds. We didn't anticipate the large development that was coming within these basins from population growth, new reservoirs that came along, the increases in irrigation efficiencies. Jeff mentioned about the development of sprinkler irrigation, not only in Nebraska, but that happened in all of our states in the western U.S., making more efficient use of those water resources, increased vegetative growth in our basins, these conservation measures we've done in terms of tillage and conservation measures on our landscape. We know that these measures have affected the stream flow, they've affected the water quality, the stream morphology, and transit loss. This is important from an administrative standpoint when we're trying to make deliveries, particularly of reservoir water, and we have to consider the amount of transit loss that it takes to get between point A and point B. Bottom line, these compacts did not contain provisions to provide that flexible and practical methods for administration with this necessary advancing age of these compacts. And I know I can speak on behalf of all the panelists here today that despite these challenges we face under these compacts with these changes that we're seeing, I don't think any of us would argue that we should reopen those compacts as a means to try to resolve these challenges. So then how do we solve these challenges as we move forward if we think we're not going to open up these compacts? And I know Preston Hartman's here today, and he knows there's never a presentation that I go forward that I don't have to cite some quote. And I certainly want to do it today because I've always, you've heard the expression about a picture's worth 1,000 words. Well, I think a quote is worth 1,000 pictures. And we can all certainly take from quotes and read a lot into them, but they certainly provide a lot of guidance for me. And I think about this role that I've been in, particularly as my role as state engineer and dealing with these compacts administration, and it reminds me of a quote from Albert Einstein that he once said, a clever person solves a problem, a wise person avoids it. The nice thing about using a quote from somebody who no longer lives is we can take our own prerogative in trying to interpret what that quote really meant. And I think you look at one aspect when you hear that quote, and you may interpret it to say, well, if we ignore our problems, they're going to go away, right? Well, I think we've learned in a very hard way, particularly in Colorado, that ignoring the facts out there doesn't make the problem go away. We certainly learned this to be very true in the Arkansas and the Republican as it relates to the groundwater pumping. Certainly another way to interpret it is if we work cooperatively in addressing potential conflicts, we could avoid having to solve a much bigger problem later. And this is where I've found that the value of these compact commissions that were established as part of these compacts. As Karen mentioned in the biography, in my role in administering these 9 interstate compacts and U.S. Supreme Court decrees, I sit as commissioner on 5 of these compacts. And it's these commissions that often through the assistance of engineering advisors that are part of our staff and our legal advisors, that's led to the cooperative efforts between our state officials. As mentioned, some of our efforts right now on the Republican, we're meeting monthly to try to work towards some long-term resolutions of some very long-standing problems between our states. But the state officials are trying to work through these commissions to prescribe procedures for the administration of these compacts. And this is really, if you will, you kind of look at it as kind of an amendment to some degree conceptually to these compacts that are out there without actually having to amend the compact. So we do that through these cooperative agreements. We've been through these commissions, been able to try to address, investigate alleged violations of the compact, and really tried to bring them to the attention of the state officials before a state just goes forward and files some lawsuit on the other state. And you know what that generally does. People get polarized and they lawyer up and off we go. In the Arkansas River Basin, as part of this litigation that went on for 24 years, once those efforts were settled and we got a final decree, the states worked on developing what we refer to as an issue matrix. And this has about 35 issues that remained. And these were issues beyond what was litigated in the case between the two states. And we currently try to address those in a collaborative way. We meet on a regular basis, again with our engineer and legal advisors on this, trying to address those issues, trying to prevent any of those becoming specific cases that someone could file a lawsuit over. And one of the lessons that I learned in working in this litigation through the Arkansas River Basin was very clearly made by the U.S. Supreme Court justices about Colorado, and certainly any party to a compact, our fiduciary and statutory obligation to comply with those compacts. And that certainly rang true for me because of my experience starting out representing Kansas in that lawsuit, and then ultimately working for Colorado in the implementation of the decree that came about. But this has led to a proactive approach to our administration of our compacts. And by way of example, in the Arkansas River Basin is addressing some of these issues as a result of the compact and this issues matrix. State of Colorado has adopted well measurement rules. We've also adopted well use rules for the wells in the basins, how they'll operate. And most recently, I adopted rules and regulations regarding irrigation improvements that one must consider if they're increasing the irrigation efficiency on surface water systems. They need to be mindful of any compact implications. Certainly one of the consequences of dealing with these kind of proactive approaches with these compacts and addressing these issues is we've had to go to the legislature to request more staffing to not only deal with just hiring staff, but also the technology oftentimes that's needed as part of these. We've got some very complex computer models that are used as either part of that came out of the litigation or part of what we're doing for some of the rules and regulations we're doing. So we think about that's where we're at, and we're looking forward, all of us in our respective capacities as compact commissioners on these various compacts, and we think about where do we go from here. And I think we talk about this role we have as commissioners in trying to set the stage for our successors to try to avoid litigation. Certainly that's been my goal as a state engineer in Colorado, and working with my counterparts here. I think we're making some very good efforts in doing that. We hear about this, the buzzword collaboration. We've got to collaborate on these things. But I think if you look closely at that word collaborate, you'll see the word labor in there. And that's so true, because I'm sure all of you who've had to work through a process of collaboration, it takes a lot of work. And it really takes a lot of work. I respect all of these individuals up here. We dedicate a lot of resources, not only our time meeting monthly in terms of addressing these issues that are out there, but our staffs that are in there, our attorneys that represent us. So it takes a lot of work to collaborate, but it is important in how we're going to move forward. I think as part of this effort of where we move forward and trying to avoid getting into future litigation and trying to maintain this atmosphere of collaboration, we've got to be transparent. I think with our efforts and our roles, we've tried to make all of our actions more transparent. The data that we provide that people can check us on with technology, we've made that available via the internet. People can be looking over our shoulder and making sure that what we're doing out there, what we say we're doing, is very transparent and they can check it. One of the other things we've learned in our roles too is we've got to be good listeners. If you're doing all the presentation and talking is like we're doing here today, you're not learning anything, but you certainly will learn if you listen. And we've all, I think, exhibited that in our negotiations. And ultimately through all of that, and that by doing that, we can learn to trust each other. And that's certainly how we can try to deal with these conflicts that come up, how we can work collaboratively. I think about my predecessors in those roles and what they did in terms of trying to trust those that they were working with. That's how they reached these settlement of these compacts, and certainly that's something that we are trying to do. We need to continue to involve stakeholders. Again, that's part of that collaborative effort, but it takes a lot of time and effort to do that. One of the things I've gained a great appreciation of, even though I'm an engineer and a regulator, is the recognition of the value of our environment. This certainly can't be more clear in our recent issues we're dealing with in the Rio Grande. There's been many lawsuits filed there in the last recent years regarding alleged impact to the environment and to its species. But we can certainly, I think, need to work collaboratively in there, because I see one of those things, if I think about where we head in the future there, I think we've got to avoid the ultimate clash of the titans between the ESA and the compacts, because I'm not sure who would win out. I'm sure all the attorneys that are here in this room certainly may have some opinions about that. But as a regulator, I'd certainly want to try to avoid being in that big clash. But I wanted to at least recognize my colleagues here that are here today on this panel. I can consider them all my friends, and that's partly because I've developed a trusting relationship working with them and what we represent in our roles for each of our states. And I think that demonstrates our commitments to work on these compacts and trying to solve these daunting challenges ahead of us. And so, and I'm confident if we continue to have these trusting relationships, not only in the states that are represented here today, but our other sister states, I'm sure we can meet those challenges there. And I'll certainly, wouldn't be past me to close with a quote from Peter Drucker, who says, if you want to predict the future, you need to create it. So thank you.
And finally, we have the state engineer for Wyoming, Pat Tyrrell. Pat's a native of Wyoming who grew up in Cheyenne, but also lived in Casper, Gillette, and Laramie, and Minneapolis, Minnesota. That's not Wyoming. Oh. His experience was entirely within the private sector until taking the appointment as state engineer in January of 2001. In his role as state engineer, Pat serves as Wyoming's commissioner to the Upper Colorado River Commission, and he represents Wyoming on the North Platte Decree Committee, the Colorado River Basin Salinity Control Forum and its related council, and is the current chairman of the Western States Water Council. Pat was Wyoming's commissioner on the Bear and Yellowstone River Commissions from 2001 to 2012. He's a past board member and past president of the Wyoming Water Association. Prior to being appointed as Wyoming state engineer, Pat was engineering manager of State's West Water Resources Corporation from 1995 to 2000. He served as regulatory affairs supervisor for the Thunder Basin Coal Company from 1991 to 95. And prior to those roles, he also worked with Wenke Associates and Western Water Consultants in the mid-80s, right? Close enough. Pat earned his BS with honors in mechanical engineering from the University of Wyoming in 1979 and an MS in civil engineering from the University of Wyoming in 1982. Please welcome Pat Tyrrell.
Blaine, thank you for the invitation, and it's a pleasure to be here with these gentlemen, and I work with Karen quite a bit, so it's very nice to have her as part of the introductory effort here today. Thank you, Karen. Going last is always kind of fun because I don't have to write squat before I get up here. These guys can pretty much set the table. However, I did make a few remarks, although I think what I'll start off by is just remarking about working with these gentlemen. Dick's, obviously I just learned a little bit schizoid, having started in Kansas, come to Colorado. Jeff is the same way. He left Wyoming to go do the same thing in Nebraska, and the only person I know in history that has had that position in 2 different states, which I think is fascinating, and I'm sure he's finding it interesting. And then Dave had to go to Africa to gather the weapons to come back and beat up on Nebraska and Colorado. So my question for Dick and Jeff is there anything you want me to say to Dave? Because I got nothing that flows to cancer. So he's harmless to me. My wife travels for work, and she was on the East Coast a couple of years ago, and somebody said, so what does your husband do? And she said, well, he's the Wyoming state engineer. And the answer was, wow, you only need one? And so, not everybody understands what that title is, and we go by different titles these days. But but that, yes, one in some cases is one too many. But what we have, and I'm going to take some of the comments or derive some comments for the group based on just the words that outline the task of this panel, which is perspectives on administration of compacts. And as a state engineer, what you find is that it's your job, if you're not in suit, obviously, to implement language that is sometimes less than clear, written 60 to 90 years ago. And for example, if you look at even the Upper Colorado River Basin Compact, or actually the Colorado River Compact, it says that the Upper Basin states simply won't deplete the river below 75 million acre feet in a running 10-year period. That sounds pretty simple until you sit down with your staff and maybe the commission, or you try and figure out, so how do I do that? What happens in a year when the previous 10 years have been 7.55 or 75 and a half? How much do I curtail? What do I curtail? I still got a whole winter ahead of me. I don't know if it's going to snow 15% of normal or it's going to be 1984 all over again, and in which case I wouldn't have to curtail anybody. So there is language in these older compacts that I think they got them approved, they got them ratified, they could agree at the time, but I'm sure as they walked out of the room they said, well, thank God we don't have to figure out how to administer this summer. We'll leave that, we're happy now. And of course you have compacts that were developed because you could agree at that time. You have decrees where you couldn't, and you ended up in court. And as some of us know, you have both at times. Differences in state water laws can contribute to very different opinions, even at compact commission meetings. For example, the duty of water across state lines can vary. In Wyoming, we issue surface water rights for 1 CFS per 70 acres. The duty of water in Montana on the Tongue River averages about 1 to 40. So I am sending water from one state to another that allows more on each acre. That certainly raises discussion. You may have differences across state lines as to what constitutes a full reservoir. In Wyoming, we get one fill, but that is not constant or the rule across every state. We all have little idiosyncrasies in how we manage under the priority system and how we administer our water. So priority of appropriation might be in some cases about the only common thing we share. When it comes to implementing it, administering it, we can be different. And that's where these things that can arise, that can ultimately, as Dick was talking about, you lawyer up and you end up in court, which frankly I don't think any of us like that. As a result. You don't want to be there. You want to be delivering water to your folks and living under your decrees and compacts. But states are naturally skeptical of their neighbors. If that communication isn't transparent, skepticism leads to distrust. We saw some of that arise in the North Platte 20 to 30 years ago. We ended up in suit. I saw that happen in Montana v. Wyoming. We saw that end up in suit. Luckily, we're almost done with that one. But a gentleman from Utah had a great quote one time, or a point to make. He said, "What do water and sex have in common?" And the answer is everybody thinks their neighbor's getting more than they are. And that is the skepticism that can lead to, in Wyoming's view, we always figured that Nebraska thought we were growing rice and tomatoes. Sugar cane, some water-loving crop in Wyoming. So what you have to do, though, that skepticism is natural, but you cannot let it fester into distrust because you will regret it. So state engineers have two roles, or can have two roles. You can be the cause of an interstate suit under a compact, or you can prevent it. In the former, I know that can happen because I've seen me do it. Refusing to regulate under a compact caused us to go to, and I firmly believed I was right. The court told me I was wrong, but that caused a suit that's now in about its 8th year in Montana. Former Wyoming State Engineer George Christopoulos had a real hard time regulating tributaries to benefit the North Platte. We got that one tossed back at us, and we now regulate tributaries to the lower North Platte in Wyoming. So you have a role. It's kind of how do you want to play it, and if you can do the prevention, you're far better off than being the cause of something that can be quite expensive. Another perspective is you have to mind your manners at home. It is very difficult for me to defend all my water users against an interstate or under a compact if they're not minding their manners at home by protecting their own water rights, putting them to beneficial use, keeping them up to date, maintaining the non-forfeit status on those water rights. Everybody in each of our states probably thinks, because how many western states have a constitutional clause that say all the water within our border is ours? Wyoming does, I know many others do. That causes your residents to say, well, as long as that water is in Wyoming, it's ours, right? We can do with it whatever we want. We're going to dam up. And there are people out there. We had a gubernatorial candidate 2 years ago that ran on the theme or told me that if he gets elected and I'm a state engineer, we're going to build dams on every river. That is, he didn't get elected. And if he had, I would not be standing here because he would have fired me or I'd have quit because that's ridiculous. The water in your state is yours, then I got to allow Colorado to dry up the North Platte border. And the Laramie, we already found out from Justice Hobbs that can't happen. So you got to mind your manners at home. You got probably, and I know we're getting close, I don't want to run out of time here, I will preempt a couple of my comments. But I'd say, let me wrap up by saying, state engineers, one of our primary responsibilities is, and perpetual responsibility, is to educate our own constituents on what compacts let you do and what you cannot do. And I know Dick has probably been all over eastern Colorado on the Republican and the ARC. I'll stay out of that one. And others talking about minding your manners. It's very difficult for me to defend our water use against another state if what we're doing is out of control. So that's an educational thing that can keep you out of trouble. In Wyoming, by the way, we do have 7 compacts and 3 decrees. Compacts all around the state. Now, not all those compacts have commissions, by the way. Colorado does, the Yellowstone does, the Bear River does. But the Belfouche does not, the Niobrara does not, the Snake does not. Yet we meet with those counterpart states at least annually to talk about the issues in our state and theirs, in the issue of that transparent relationship, so that we don't have the skepticism that can lead to distrust on any of the basins. It has before, it probably will again, but my role now going forward is to keep that from happening. Irrigating is cheaper than litigating, so I think, because we've got about 5 minutes if we're going to stay on schedule, I think I'll just stop there and we can go to Karen, go to questions.
So one question I just want to pose to you guys really quickly before we open it up to the audience is, I've heard from all of you that the likelihood of, while it's complicated to implement a compact that was written 50, 60 years ago, or 90 years ago in some instances, the concept of reopening it is less than exciting and very unpalatable. But you have to meet regularly, you have to develop relationships, and we're naturally skeptical of our neighbors. So how do you see in your time frame, or when you are moving on, how do you maintain the copacetic and smooth sailing of the compact implementation as personnel changes, lawyers change, state engineers change, relationships change? Do you see any of that? What's your suggestion for that?
Go ahead.
I don't know. In some sense, I think part of this job that I didn't quite realize at the beginning is being an ambassador. And if you are simply an engineer and you cannot engage with your neighboring states, you're going to end up getting, either you're going to get your state in trouble or you'll have a pretty short career. And that ought to be appropriate. In fact, every one of our governors ought to interview with thoughts like that in mind. I don't just want an engineer. I got to have somebody that can manage me through issues that can involve litigation and maybe differing personalities in the other states. Personalities can be a big deal. Jeff mentioned it. We had to change personalities in Nebraska on both sides, frankly. Nebraska v. Wyoming to get to a settlement, and I have to say he was right. What was crafted works on the ground, and our relationship with Nebraska now is the model that I want to get to, and we will with Montana in a couple of years. Jeff would have never guessed that 20 years ago. But you have to be able to turn that around, and I'm proud of that relationship today.
I'd maybe just add to that too. I think, as Pat commented too, there is only one state engineer in each state, and certainly I recognize that in my capacity I could not get done what I do without the great staff I have, and I think it does start at the top all the way from the governor down to the legislature and into our organizations. But I think what I've tried to achieve, and I think all these folks do too, as we go through the changes in our staffing, to the extent that you instill in the staff that's working on these compacts and these matters a willingness to support these ideals and these visions we have on how to cooperate, I think as we leave in our various capacities, there's enough momentum with the staff that's there that kind of carries that on, even with all these changes. And that's how I've seen, just like in the Arkansas River Basin with the staff that's down there that deals with this on a lot of the day-to-day basis. As we see the changes down there, those new people that come in are learning from those people that are there. And so you really got to continue to work on a day-to-day basis to promote that harmony within those staff that are still there working on each of those basins.
I'm going to open it up for anybody who might have questions for the panel. Well, I'm going to ask one more question.
There's one back there.
Go for it.
Gentlemen, is there a regional discussion of climate change and its impacts on hydrology? It's been mentioned, but it's not clear how we can adjust without a great deal of anticipation.
Your state.
Yeah, I know Colorado is very active in the discussions climate plan. The Colorado Water Conservation Board has published a report that's out there. Go look on their website. It does build on from these more regional and national, if you will, models that are out there on the effects of climate change. And I know the other states, you know, they're probably all at different levels on looking at that and how we're going to address it long term. So I think through like the Western States Water Council, there's that broad discussion amongst the 18 or 19 Western states as it relates to climate change. And again, I don't think there's, given that we're in kind of that beginning or nascent part of addressing the potential effects of climate change, I think a lot of the thoughts and potential processes that are going to be deployed on that going forward are still being worked on and developed. But I think that report that Colorado prepared, and maybe the other states have got similar thing, I think provides a lot of great insight into that and what we need to try to plan for and adapt to as we see our climate change.
I was just going to ask you, Patrick, I like your comment about kind of minding your manners at home. Can you guys talk about some of the things that water users in your states are doing that drive you crazy or that are happening very well that kind of support you guys in what you're doing?
Go ahead.
Go ahead.
That's a great question. I mean, it's a wide range of stuff. I think in the short time and the shift that I've been to, I mean, irrigated agriculture is everything in the state of Nebraska. So none of that's taken very lightly. And quite honestly, it is very difficult from the outside to impose change at all. And so it takes a tremendous amount of personal effort to engage the producers. And it's really producer to producer where you're going to get the most change. And so in our state, it's, you know, there's areas where if they're not pumping 30 inches of water out of their well, they, you know, that's the way Granddad did it, and my dad did it, and I'm teach my kids to do it. And then you have other areas like in the Republican where they've been ratcheted back as we've done everything we can, and we're going to continue to ratchet back. They're down to sort of 13 inches per year kind of caps. And guess what? They're growing the best crops they've ever had. And so, but nobody could have told them that. And so it takes a long time to educate and to enforce and to get them convinced that they can do that. But the peer-to-peer will go way better than anything else. Wait till the guy that's using 13 with a really good crop and all the new equipment on his farm, and the guy that's paying huge pumping bills because he's putting 20 inches on, they don't like to pay pumping bills. Those are sort of the drivers that we see to change that behavior. But in my case, I think it has to change. Where I'm heading already is the issue of Nebraska hasn't used the word sustainability nearly enough. They are just used to having the fat end of the Ogallala as an example. And we're like, sorry, Kansas, we just got the better piece of the pie. You're going to pump it till it's gone. We seem to not be able to pump it to even lower a foot. I mean, it's unbelievable. I have 50 years of pumping. We have areas where the groundwater table is higher than it was 50 years ago. And they're pumping everything they possibly need. It's just it's a weird dynamic coming from Wyoming to witness sort of that kind of water supply. But it has to stop. The Republican is the great example for the state of Nebraska. If you just keep acting like it's infinite, you will finally get whipsawed. So as I travel the state, I hear a lot about, we don't want to be like the Republican. And I'm like, yeah, you don't. It isn't that much fun. So you do have to change your at-home behavior, or Nebraska is going to have problems with other river basins just like we had in the Republican.
Let me just add to that sort of what's in the back of my head. There is no western state where every water right within that state is 100% perfectly in compliance with its own terms. Ranchers go out and build stock dams in Wyoming without permits. They get a D8 for Christmas, they build a pond. So what I mean by minding your manners at home is, do your water uses all have permits on them? Are they putting the water on the right lands? Are they using the right point of diversion? If they have changed, do they have a petition process to cover those lands? Because of what happens is when you get into an interstate contest, your neighboring state will know as much about your water use as you do. So what you've got to do is go out to your own folks and say, you've moved your point of diversion from the tributary to the main stem. You didn't tell us. You need to get that processed in a petition, because when Montana or South Dakota or Nebraska asks about it, you're a bruise on our system here. So that's what you got to do. You got to operate a water right's a property right. Treat it like a property right. Keep it up to date. Have it run according to the terms of your permit, because it's no less important to you than the taxes on your property and the boundaries of your ranch. Keep it up. Keep it going right. Then I can defend you. If you think that this is something you can do with impunity, I can't defend you.
Well, thank you all, gentlemen, and thank you, everybody, for a great conversation.